Well, good afternoon, everybody. Glad you showed up. Today, what we're going to do is we're going to be talking about long-term care and the public benefit that it takes to actually have it paid for. You know, one good thing about California is we can shelter all our assets when it comes to long-term care, and we can actually save them, preserve them, and get the public benefit to help pay for that long-term care. As a little introduction, my name is Dale Bethel, Bethel Law Corporation. I'd like to show you this slide right here because it does give you a little bit of an idea of what we do in the office. As you can see, everything spins off of estate planning. And when it comes to estate planning, those of you who don't get around to doing what I ask you to do in terms of setting up a living trust, does mean we end up going into court. So we do our probates. We do our trust administrations when it comes to people passing away. We help the families wrap up the trust estates and make sure everybody's getting what they're entitled to, along with an accounting. We do a lot of business and corporate work, and we also do a lot of advanced estate planning for the very wealthy. Now, today, what we're going to do is focus on the elder law box that's right up above the estate planning box there. And what we do in elder law is something we've been doing for a good 30 years now. We organize and write our trusts and other documents in such a way to include certain Medicaid, Medi-Cal type language so that when the time does come, the family has the legal authority to rearrange and shelter the estate is what we're going to talk about. So writing is very important when it comes down to the documents. We'll kind of go into that for a moment. But today, the whole focus is really going to be elder law and the part that we play in our firm when it comes to handling elder law type issues. So that's going to deal with Medi-Cal, Medicaid. That's going to deal with certain VA aid and attendance. There are certain types of trusts we can use. And we also get involved with a lot of other issues like constant counseling when it comes to long-term care. There's even placement concerns, and there's a lot of other Medicaid, Medi-Cal issues that do crop up that today we won't get into because we're going to focus mainly on the exact type of benefit that you will need if you have to go into the nursing home. Now, our background is, again, about 30 years of doing it. I've had a lot of great workers that help me in this process. Currently, we're working with Marge Fatante. She has worked on the government side of denying people public benefit money for about 20 years, and now she and I have been working together for a good 15 years or so at that point. So she's very knowledgeable. She's the head of the team here, so to speak, when it comes to dealing with these issues. She's very good at interweaving all the other types of insurances or outlets you might have when it comes to paying for long-term care and interweaving them with the Medi-Cal process itself. So with that in mind, a lot of people always ask me, when they start inquiring in our office about this issue, and usually those that are inquiring are actually the children. So if you have parents out there, you're probably watching this presentation knowing that at some point your parent or parents are going to be heading into this issue and just what to do. What do you do, especially when it comes to concerns about how all of us do not want to go to long-term care, into nursing homes. I don't think there's one person ever I've met that actually wants to do that, but it does become a reality at times, and so that's what we're going to be talking about today. And the big question people ask me when they first inquire or start to inquire with me about Medi-Cal is the timing. When do we do it, right? Now, that's really hard to answer because it's like looking in a crystal ball to figure out when's the best time, to get started on this. If you start too late, we could still get it taken care of. Too late simply means that you already have the need. If you start too early, there's no need, and you're speculating then as to when that time should start. Well, I always like to show this slide here because it does give you an idea how to think that process through. There are some preliminary matters that we can take care of, and you can start talking to your parents about this and what to do. And it has nothing to do with taking over their assets. It simply has to do with getting them a little bit organized for that moment that if we have to qualify for Medi-Cal, it'll make life a whole lot easier. So first concept would be to consolidate their assets. One of the difficulties is when you have monies, all over town in various banks and all over the state or maybe all over the country. So there's a good idea to get everything consolidated. I like consolidating things into specifically one brokerage account, one checking account, and maybe one small savings. If you can get that part of it organized ahead of time, that will speed up the matters and stop the panic at the moment. Now, the other issue has to do with rental properties. If your parents or you who are watching have rental properties, they are always a little bit difficult to handle when it comes to Medi-Cal planning and getting the Medi-Cal type benefit. There's not a good solution to this. I mean, I'm very happy that you have rental properties. Don't go out and sell them and give them away. There's a bunch of tax issues that needs to be discussed and when it comes to that. How we shelter rental properties is the same way we'd be sheltering the money. I'll go into that on a few other slides up here. But if there is some way or some plan within the family to move rental properties, it might be a good idea, based on the tax concerns, to move the rental properties way ahead of time. But again, it's a tax issue, let alone just the feeling of, I'm giving away everything I worked my hard life for. So I understand all those concerns, but rental properties can be dealt with. But they are a little difficult to deal with, and if there's a process within the family to maybe tackle those issues ahead of time, it's always good to do so. Now, the most important part, in my opinion, really comes down to just simply having a revocable living trust. Anybody with a house, anybody with rental properties, of course, anybody with more than $166,250 of tangible assets, money in the bank, brokerage firm, so to speak, has a probate. So anybody that has a house, has rental properties, or more than $166,250 simply needs a revocable living trust. And why I'm emphasizing this, not in the contents of avoiding probate, which is what should be motivating you, but in the context of getting the special language or special powers that will be needed when it comes down to Medi-Cal type planning. And what I mean by special powers or language simply has to do with the fact of giving your family authority to go ahead and shelter your assets when the time comes. The assumption being that you may be incompetent at that point or incapable of making these types of decisions or understanding the importance of them. So by having the language in your own revocable living trust and or your own financial power of attorney will provide the family protection in the ability to move monies around and shelter them and not be accused of elder financial abuse. It also provides authority from you to them to actually do this if in fact the opportunity does arrive. So the foundation of everything we do, of course, starts with language in the revocable living trust and or the financial power of attorney. If you have those documents already, I'll be happy to review them and make sure that the language is already in there. If not, we can easily add it as an amendment in that sense. So when it comes down to Medi-Cal planning, Medi-Cal is really the only public benefit for long-term care. In California, we call it Medi-Cal, and in California, it's completely different than the 49 other states that are out there. So if, in fact, you are going to end up in a long-term care type facility, I would suggest you not move to Maine, because in Maine, you cannot shelter the assets like we're going to talk about. California is the only state in the nation that allows to do that. So what we're going to talk about is the protection of your assets from Medi-Cal spend down. That's the word that everybody hears. Spend down means you have to, as a ill person who's receiving the benefit, you have to get down to less than $2,000 in order to get qualified. If you're the well spouse with an ill spouse needing the Medi-Cal benefit, your spend down will come down to about $128,000, say $130,000, and whatever may be exempt. But if you have more than $130 some odd thousand in savings, brokerage accounts, etc., we'll have to shelter them, and that is what we call the spend down. Now, we want to also avoid any kind of recovery against your home. I mean, besides qualifying for Medi-Cal, one of the biggest issues when we go down this path is not only to get you qualified for the benefit to pay for things, but at the same time make sure that the state of California under the Medi-Cal program has no right to come and, well, collect against your estate for money spent on your care. Now, typically this is a recovery claim against your home, but we have special powers in the trust that we've already mentioned that also deal with sheltering of the home. Now, there is a new rule as of January 1st, 2017, that so long as we're avoiding probate on your house, that is, using a living trust, state of California will not come after that home for money spent on your care. But there's a number of other ways that are much more practical on how to shelter the home, which we'll get into here in a moment. Now, really what we're involved in is making sure legally that we can turn countable assets against you. What I mean by that, countable assets are what counts against you, when it comes to qualifying for Medi-Cal, and we want to shelter them into maybe a protected asset form. So one of the preliminary matters that you could do is if there is home repairs that need to be done, on the parent's home, things have been neglected for a while. Maybe it needs a new air conditioner, it needs a new yard, it needs some kind of plumbing issues, roof issues. This is the time to get that stuff done, because spending countable money that will count against you for qualifying for the Medi-Cal on a house which is not countable is a good way of spending down the money without having to go through the gifting that we're going to talk about later on. You always want to get that house ready for sale one way or another, and this is probably a good time to think about doing those types of things if in fact you can afford to do so. Now, when it comes down to the special rules for California that I've been talking about, why am I saying only in California you can do what we're going to mention? Well, it's because California is still running under the federal Medicaid rules that were established in the 1980s. And those federal Medicaid rules that were established in the 1980s allow us to do everything we're going to talk about. We are allowed in California to shelter our savings, our monies, our stocks, bonds, mutual funds, shelter our retirement plans. We are allowed to shelter our real estate, and then immediately turn around once that sheltering has been completed and qualify for the Medi-Cal benefit. In the 49 other states that run the federal Medicaid program, they've already adopted more restrictive federal Medicaid program or rules that have come down the pike in the last, say 20 to 40 years. And the reason the rules are changing at the federal level is because they're getting ready for us baby boomers to go through the system. You know how the baby boomers have changed the economies of everything that they buy throughout the same time, turn around and qualify for the Medicaid benefit. So in those 49 other states, the general rule is there is no gifting or movement or sheltering of any kind of money or assets 5 years prior to going into the nursing home, which makes it almost impossible to pre-plan, 5 years ahead of time. So in California, the good news is that there is no concern about a look back. Even though they look back, our concern in California is if we move any type of assets, real estate, monies, that it does not create what we call a period of ineligibility where you cannot go in and qualify, for the Medi-Cal benefit. So that's what we're concerned about in California, not so much looking back, but making sure that whatever we're sheltering doesn't create a period of ineligibility where you're not allowed to qualify for the Medi-Cal. Or I should say at least receive it. I'm not sure what the program is for California. Maybe they're just a bunch of nice guys, so to speak. But quite frankly, it's almost like California is telling the rest of the nation, hey, if you want to go on long-term care, come to California and we'll let you shelter everything you own and get on the public benefit for you. So that's why California is special. I have a lot of clients that will ask me, well, I'm thinking about moving my mother back to Tennessee, and taking care of her. Well, if you do that, you will not be able to do what we're now going to talk about, and her assets will be exposed to the total spend down. So with that in mind, there are certain ways that we have to qualify for the Medi-Cal benefit. We have to become eligible. And so when it comes down to that eligibility, you might want to think of that as restrictions. These are the restrictions that the Medicaid, Medi-Cal program put on us individuals when it comes to qualifying for that benefit, that need. Now today we're going to focus on a medical need. And what I mean by medical need when it comes to Medi-Cal planning means that we have to go into long-term care facilities. There are a number of other types of Medi-Cal type programs that are starting to become available out there ever since the induction of Obamacare. Hopefully in the near future we'll have a presentation when it comes down to those other types of Medi-Cal programs that are available. But today we're going to focus on the medical need, the need to go into a facility because of medical reasons. So even though Medi-Cal is a government-run program, there are restrictions on how to get into it, and this is what we do when it comes to the planning. So the first thing we always have to worry about when it comes down to Medi-Cal qualifying terms is your gross worth. When we qualify for medical need Medi-Cal, it's all about what assets you have. And again, it boils down to whether or not an asset is going to count against you. That's what we have to shelter versus an asset that's already going to be protected anyway. So with that, the other big issue is outside of tangible, gross worth like money in the bank is our rental properties or our principal residence. Now, our principal residence is really easy. I've kind of alluded to this already in the sense that the principal residence is exempt. It doesn't count as an asset for qualifying for the Medi-Cal, but if you leave it sitting around with your name still on it and you happen to pass away after receiving the Medi-Cal benefit, the state of California, come after that home to collect against it for money spent on your care. Now, the good news is, like I've already alluded to too, is as long as you have a revocable living trust, you're avoiding probate on that principal residence, which means that the state of California, as of January 1st, 2017, will not come against the principal residence to recover for money spent on your care. However, there's issues with just leaving a house sitting there collecting weeds while you may have to be in a long-term care facility, and we'll get into that. Now, again, rental properties are an issue. I've kind of alluded to that already. We have to what we call gift stack rental property value out, just like we have to gift stack money value out. And I'll show you what I mean by that on the next slide or two. Now, the probate rule here, avoiding a Medi-Cal recovery claim on one's estate, that's what I've been alluding to in terms of getting a revocable living trust. Avoiding that probate on that house now avoids the recovery claim when it comes to Medi-Cal. All right, with that in mind, you're going to notice when we go into the planning that there's really two approaches, two issues that we have to deal with. If, in fact, you're a husband and wife and you have one ill spouse and one well spouse, when it comes to your house, we just transfer the house to the well spouse. If you have rental properties, however, we have to shelter them in another manner, which I'll show you here in a moment. But if it's husband and wife, we just move the house out of the ill spouse's name and move it to the well spouse. Now, that sometimes is a trick when it comes to maybe having a large basis in your home. In other words, I deal with this issue a lot in the Los Angeles area. Here, parents have bought homes in the LA area for $30,000 60 years ago, and now they're worth $3 million. So there's usually a large basis, or I should say a small basis in that home, but a large capital gain hit on its appreciation. So we may not want to transfer a home out of an ill spouse's name, but just let it stay there. And if the ill spouse passes away, you now achieve a 100% stepped up tax basis on that house, which could be very beneficial for the family and for the surviving spouse. So number one, we're going to take care of the house, but number two, we got to take care of the movement of funds. Now, again, the actual monies that we're talking about is the ill spouse has to have less than $2,000 in their name, and the well spouse has to have what we call something less than the community spouse resource allowance. So what I'm getting at is the well spouse can keep upwards of about $130,000, and anything above that has to be moved and sheltered. Okay, so with that in mind, let's discuss what it's like to be husband and wife, where you have one ill spouse and one well spouse. So in the top left-hand corner up there, you can see we have husband and wife. Hopefully you have a revocable living trust. And what we want to do is we need to get the ill spouse down to, less than $2,000. So as you can see, the arrow points directly down from husband and wife to wife. I guess we're picking on husband today as the ill person in this diagram. So what I'm getting at is simply this. All the monies and all the real estate, including the main house, gets transferred to the spouse, unless, of course, there's a huge capital gain issue that we have to deal with. Now, once everything's in the well spouse's name, we create a new well spouse revocable living trust. And in that revocable living trust, we're going to disinherit the ill spouse. I know that may sound cruel, but actually it's protecting everybody. If the well spouse, for some reason, should pass away before the ill spouse, sometimes there's, car accidents, heart attacks, things of that nature, cancer, that will take the well spouse long before the actual ill spouse who needs the long-term care. In that event, we do not want all the property going back to the ill spouse who's on the Medi-Cal and ruining the Medi-Cal and all the benefit that we've now spent a long time getting up and getting prepared for. So, as a result of disinheriting the ill spouse from the well spouse new revocable living trust means that if the well spouse passes away before the ill spouse, all the property goes out to the family as an inheritance, which is not a gift, which means it doesn't upset the ill spouses or parents' long-term care Medi-Cal benefits. Now, what if the money that's transferred to the well spouse is equal to more than, here's the figure, $130,380? If there's more than that, we have to shelter that money. And the way we usually shelter it in our office is we pick a trusted son or daughter within the family. Sometimes we can pick 2 people or even 3 people. But my point is simply this. Usually the one that you're picking for the successor trustee is the one son or daughter that you do trust in this instance. And we'll usually pick them to work as a conduit. We'll want to move the money through them so that they can put it into a special needs trust. If I have the son or daughter, transfer the money through them and then into the special needs trust, I can design that special needs trust where the first beneficiary is the well spouse, which simply means that if the ill spouse passes away and the well spouse wants the money back, the money can come right back to them. And that's why I have that dotted line leading right back from special needs trust up to wife, who is the well spouse in this diagram. Now, the second beneficiary of the special needs trust, of course, is the family. Unfortunately, a lot of times when I get involved in this situation, the first spouse that goes in and then passes away, usually by that point in time, the second spouse is ready to go through the system too. So we just take the last $130,000 that was left over in well spouse's name, which is the new ill spouse, and we just transfer that through the son or daughter again into the special needs trust. Now that special needs trust ultimately becomes, the distribution trust out to the rest of the family when both parents have passed away. Now, the gifting of money. The one thing I do not want you to do is write, say, a $300,000 check over to son or daughter. If you write a one-time big check like that, you are going to create a period of ineligibility under the rules of California, meaning that the moment you write that check, you cannot go into Medi-Cal and get qualified for the benefit because it does create that period of ineligibility. One way to figure out that period of ineligibility is you divide $10,000 into the amount that you're actually gifting. So in our example, it's $10,000 into $300,000, and that tells you how many months you have to wait in order to actually go in and qualify after you made that gift. That's the rule in 49 other states, by the way. Because now what I'm going to talk about is because California is working under 1980 federal Medicaid rules, we're allowed to move this money, but we have to move it according to the rules, right? And the rules are basically this: as long as you gift away per day something less than the average nationwide cost of a nursing home per month, then each gift per day never creates a period of ineligibility. So, for an example, the average nationwide cost of a nursing home per month is a public figure that comes out from the federal government about every April. And right now, I think it's up around $10,280 or so. So if we gift something less than that amount per day, then each gift per day will not create a period of ineligibility, which is why we actually picked 10,000. So as you can see on the chart, it says gift at $10,000 per day. So you're going to divide $10,000 into whatever amount above $130,380 we have to shelter. And that tells you how many days it's going to take to actually move the money. So we're going to mechanically, if it's only about $100,000, we're going to sit down at the kitchen table and we're going to write 10 checks, 10,000 per day, Monday through Friday, and then Monday through Friday again. Now we've moved, and then we're going to date them on each different day, Monday, Tuesday, Wednesday, Thursday, Friday, and the same for the following week. And then once all those checks are written, we photocopy them and we hold them in our file to turn over to Medi-Cal to show them exactly how we moved that $100,000. Because when we go into Medi-Cal to qualify and ask for the benefit, they are going to look back. They're going to see that the $100,000 was moved, but how we moved it never created the period of ineligibility, which means in 2 weeks' time, you're eligible for the Medi-Cal and you get it. That's the bottom line for California. So the amount that we're going to gift depends on how we're going to actually do it. You know, if it's like $300,000, like my first example, that may be too much money just to sit around the kitchen table and write a whole bunch of checks on. A lot of times we'll use a brokerage firm. The brokerage firm will wire transfer $10,000 per day, say from wife, the well spouse, to son or daughter, and then from son or daughter immediately into the special needs trust. I then will get a printout from the brokerage firm showing how the wire transfers took place at $10,000 per day. I hand that over to the Medi-Cal worker to show them how we moved the money, and it's accepted, and you're immediately eligible for the Medi-Cal. Okay? So when it comes to movement of everything from the husband and wife to the well spouse, we are going to transfer the home, and we're just going to leave the home with the well spouse at this particular point in time. Now, what would we do if we had only a single person that needed to qualify for the Medi-Cal benefit? So as you can see from this diagram here, we are working with the two main issues I already talked about. We have to worry about the real estate, the house, because there's no spouse to transfer it to now, and we have to worry about the money. Now, because there's only one ill spouse and no well spouse, that ill spouse has to get down to less than $2,000 in their name. So as you can see, we've got that arrow moving over to the right there from wife to trusted son or daughter, and it says gift the money. Same rules apply that we've already talked about. We have to gift it out at $10,000 per day until gone. Now, a little added benefit here. If there's more than one son or daughter in the family that we can trust in terms of the movement of the money, then we can use two people. And if we use two people, like a son and a daughter, it's $10,000 per son and daughter per day. So I could move out $20,000 in one day. The other day we just did one where there's three sisters involved. They're all actively involved in taking care of mom. They're all very trusted and good people. And bottom line is we're moving out $30,000 per day. Now, once it's in son and or daughter's name, they deposit that money into their account, and then they write a check over to the Special Needs Trust. Son or daughter can wait till all the money's in their hand to write one big check over to the Special Needs Trust. Medi-Cal is going to see the transfer from, in this diagram, wife to son or daughter. They are not going to see the transfer down to the special needs trust. In reality, that has nothing to do with Medi-Cal Medicaid planning. It's just that the special needs trust is there in a sense as a safety net to keep everybody honest. It makes other sons and daughters who are not participating in the process feel comfortable and cozy that nobody's taking their, future inheritance. It's all being sheltered and it's being protected ultimately to give out to the family as the parents actually intended. So the reality is we don't want sons and daughters just holding on to the money, even though that will satisfy Medi-Cal. We want them moving it into the special needs trust. Now, sons and daughters don't own the money. They're not out spending it on trips around the world and buying Corvettes and such. They do have to wait until their parent is actually passed away. Now that the money's in the special needs trust, chances are it's not going to come back to that one ill spouse. However, a lot of times we will get this program completely set up and we'll have the money sheltered in the special needs trust, even though we are not actually going in and qualifying for the Medi-Cal yet. A lot of times families, will want the money sheltered and in place for things to get worse. But in the meantime, mom can still take care of herself. Maybe she's in assisted living, where she doesn't need the Medi-Cal quite yet. Maybe she's in board and care and she may not need it quite yet. Maybe she's living on her own and she doesn't need the long-term care Medi-Cal quite yet. That's okay. Getting the planning done is a good thing. It takes some time to do it at times. It takes some time to make sure everybody's comfortable with what's going on. And we get all that. And the sooner you can have it organized, the better, I think, in the long run, because when the panic starts setting in of the parent getting worse or really needing the benefit, maybe the parent slips and falls and breaks a hip, and now we have an emergency situation that's going to happen very quickly. The point is you're all ready for it. Everything's sheltered, everything's in place, and we're good to go. Go in and get the Medi-Cal benefit, and mom and dad are getting taken care of. Now, the other part of this is the house trust that you see up there. This is how we're going to shelter the house. Now, remember I said that if you leave your home in a revocable living trust and you're avoiding probate, California is not going to come after and collect against the house because you're avoiding the probate. However, think about it. If your single surviving parent has to go into a long-term care facility and you just left the house alone, that house cannot be changed in the sense that what are you going to do with it? A house just sitting there collecting weeds, costs a lot of money. There's property taxes, there's maintenance, there's yard work, there may be homeowner association dues. And if you're on Medi-Cal in a long-term care facility, who's going to pay for all that? So the idea here is that if you leave the home alone in the revocable living trust and you as a child try to rent that home out, that rental income has to get reported, to the parent, and it's going to ruin their benefit. If you try to sell that home after mom or dad go into the long-term care facility on the Medi-Cal, that sales proceeds has to get reported to the ill parent, and it ruins the Medi-Cal. So instead of leaving the house just sitting in the revocable living trust, which is okay for a Medi-Cal recovery program, but it doesn't do the family a lot of good to have an expensive asset just growing weeds. So what we want to do is have mom or dad transfer the home into a house trust. Now, I call it a house trust simply because we put the house in it. But in reality, it's an irrevocable trust. But mom or dad retains a right to occupy that home. And what that means is that you, as a child, can't kick them out. But you wouldn't be moving them out and putting the house in a house trust unless they were moving into a long-term care facility anyway. The real reason for having a right to occupy language inside the house trust is so that if you as the family, the children, decide to keep the home until mom or dad pass away, then you're going to achieve a stepped-up tax basis on that house as if mom or dad actually owned the home when they passed away. And the reason for that is simply this. Mom and dad's name do get off of the title of the house. It goes under maybe your name as trustee of the house trust. However, that right to occupy means they still retain that right to occupy that house. And so what this means in reality here with Medi-Cal, Medi-Cal will not come and recover against a right to occupy because it has no value. However, it's enough ownership retention that the IRS is going to allow a stepped up tax basis to occur on your parent's death, so that you can then at that point turn around and sell the home and not pay capital gains taxes as a result of the sale. It's due to the step up tax basis that occurs on that. Now, one of the best things I like about using the house trust to shelter the house rather than just leaving it in the revocable living trust is the fact that the family, as sons and daughters, you can change your mind on what you want to do with the home, and it's not going to affect your mom or dad's Medi-Cal. You can decide to rent the house out. The rental income is reported to the trust, not to mom or dad, which means it doesn't affect their Medi-Cal. You can choose to sell the home while mom and dad are in the long-term care facility. The sales proceeds go back to the house trust and you just invest the money as normal. And when mom and dad pass away, you transfer the funds out to the family like normal. You know, you can keep the home just like we already talked about. So the point is it gives the family a lot of flexibility by putting the home in the house trust rather than just leaving it sitting there under the revocable living trust. Now, a little follow-up with rental properties. Remember we said rental properties have to get gift stacked out like money. And what I mean by gift stack is gifting out money at $10,000 per day until gone. Well, when it comes to rental properties, what we have to do is look at the assessed value, which is on your tax statement, and we have to divide the assessed value by that $10,000 figure. So we divide $10,000 into the assessed value. That tells me how many deeds I have to create to transfer the home under the gift stacking rules so it does not create a period of ineligibility in moving the rental property. So say you got an assessed value of $100,000 on the home. Hopefully not in terms of investment, but anyway, let's use that as the figure. And the concept that you divide 10,000 and 100 grand, that tells me I have to do 10 deeds. And we do those deeds dated on Monday through Friday and then Monday through Friday again. We sign and notarize them all on the very last day. And then we send in an instruction to the county recorders to record them in sequence 1 through 10. And while the county recorders may not like us doing that, it's still their job. They will do it. And bottom line is that we've now sheltered the rental property. Now, we could put the rental property into the house trust just like we do the principal residence. And that's where it'll sit. Again, you can make decisions on selling it, renting it out. It's not going to accept your parents', Medi-Cal planning on this. All right, so again, this is how we deal with both a husband and wife where there's one ill spouse, one well spouse, what happens when there's a single surviving parent, and that parent needs to get on the Medi-Cal benefit. So again, this is a program for Medicaid and Medi-Cal planning that can only be done in California. 49 other states will not let us move property 5 years prior to going into the nursing home, which makes it almost impossible, to pre-plan. So if I can give any advice, don't move mom to Maine, okay? Point is, California is a great state when it comes to long-term care coverage. And I hope here in the future that we'll have other more in-depth conversations regarding Medi-Cal. There's a lot of certain Medi-Cal programs as a result of Obamacare that my clients are now getting involved in before they reach age 65. And we want to have a nice presentation for you sometime here in the future for that. continue to look out for us, and we'll be happy to go over all that. If in fact you do want to see us and hear what we have to say when it comes to normal revocable living trust, how to use a revocable living trust, and how it fits into your overall estate plan, along with all the other documents that go, with the living trust, like healthcare and financial power of attorneys, we do have our own videos up at BethelLaw.com/videos. This is on YouTube, so just go into the YouTube area at BethelLaw.com/videos, and you should be able to find us. We also have our web pages, which have information on it too. And of course, we always work where you can call our office, and you're not going to get a bill sent to you in the mail simply because you want to reach out and get some information. I have a very knowledgeable staff. I will brag about them all day long because they do know what they're talking about, and they're the greatest people in the world to work with. And so feel free to call. Someone will answer the phone and someone will answer your questions. So with that, I thank you very much for seeing us today, and I look forward to discussing other matters with you in the near future.